We're going to talk about, we've already talked about wills and trusts, but today we're going to talk about the other documents that are really important to have in your estate planning file, which is powers of attorney, both medical and financial, and a living will, and what the difference is between a living will and a healthcare power of attorney. They are very different and very important to have both.
Welcome, Officer Ty.
You doing?
Welcome, Miss Cynthia Starkey. Good to see you again.
How are you? You too?
Always love having you on. So we're looking forward to another great episode. This will be number, I believe, 3.
3 of this up, yeah.
Okay. So here we are. We're going to continue on. Obviously, Cindy, this is a big, massive topic that most people want to ignore. Right?
That is correct.
I imagine that you tend to talk to a lot of people at later stages in life.
I do.
So what percentage of people, just to start off the conversation, what percentage of people would you say do you talk to that are under 50?
Not many under 50. Maybe 10%?
Under 50? Under 50? So 90% of people wait till after they're,
Oh, yeah. The only younger people that I talk to, typically I handle the estate for their parents, and then they realize their parents tell them how important it is to, get documents and their estate planning in place. And typically they have children, and so they want to make sure that guardians are named for their children and conservators are named for their children in case something happens to them. But that's about the only time I ever hear from younger people.
All right, so let's test your 10%. I am 50, and do you think I have my trust documents set up?
I do not believe you do.
Officer Ty?
No, I don't.
So we proved your case. That's terrible, right? Hopefully nothing happens to us and everything's okay. Otherwise, we're going to probate and it's bad for our kids.
Yep.
Which that's what this is about. Let's avoid all that situation, and let's talk about why we need to do this. And so shed some light on us for this next episode here. We're going to be talking, I guess you said, about the supplementary documents. Is that correct?
Documents that you need. So we talked about wills and trust in the last episode, 2 episodes, and talked about the difference between them and the pros and cons. But there are a couple other documents that are really important to have in your estate plan. And those are financial powers of attorney and healthcare powers of attorney and a living will. And typically I include those. So when I do estate planning documents for people, I do them in packages, and it's either a will package or a trust package typically. And there's different charges for those. And then each package also comes with healthcare powers of attorney and financial powers of attorney. And what those are is the will and the trust mostly deal with your property after you die, although trust actually deals with your property throughout your whole life. But the healthcare power of attorney and the durable power of attorney gives people the authority to act on your behalf prior to your death. They're actually not effective once you pass away. But if you're incapacitated or you can't make decisions for yourself because you can't communicate those decisions, then you appoint somebody to make those decisions on your behalf. And that's why, so the durable power of attorney actually allows somebody to make financial decisions for you. So they can write checks, they can pay your mortgage, they can pay your bills, they can sell property. And you can have those, that power of attorney can become effective immediately, which is kind of a dangerous thing to do, or just once you're incapacitated. But a lot
Do
of
you mind pausing right there? I'm sorry. You said that can be kind of a dangerous thing. What do you mean by that? What option do you have if it's not immediate?
Oh, if you I've seen situations where, to a spouse where you'll give your spouse power of attorney, that's effective immediately, and then that spouse is maybe not trustworthy, or maybe it's a son or a daughter, and you're an elderly person, and that person isn't trustworthy, and they go and do things, they buy property, or they take out credit cards, or they sell property, and you don't know about it. Um so I typically don't recommend that you give somebody that power that it's effective immediately. I usually say, it should only become effective once you're incapacitated. Um, but you can make the choice under Arizona law for a financial power of attorney to be effective either way. The one time when you really would want it to be effective immediately is if you are maybe in the military and you're being deployed, so that your spouse can carry on and, buy property, or if you have a business together, can do the things that need to be done to keep the business running. Um, but
Yeah,
yeah,
sorry. I understand what you're saying. You're just saying immediately, as in immediately you are capacitated right now, but they still have the power of attorney to act on your behalf. Yeah.
yeah, yeah.
Got it. They're
So
incapacitated.
Yeah, yeah. So just okay.
I was under the assumption that it only kicked in once you were incapacitated. So that should that you put in place. Gotcha. Sorry. Okay. Well, I'm glad we clarified that. I didn't realize you had that distinction.
No, I didn't realize it either.
the other scenario where you might want to appoint somebody before you're incapacitated is, and this is more for the older day days before, when there's e-filing and e-signing and things like that. But if you're going out of the country and maybe you had property that you were going to sell, or a business that needed to be acted on, so you'd leave somebody in charge of that so that they could sign things on your behalf, or sell property, especially if you're in real estate and you are buying and selling property all the time. But now that, you have e-signing and DocuSign and those kinds of things, it doesn't really matter where you are in the world anymore. You can pretty much act from anywhere. But, yeah, so typically that's when when you don't want to give somebody control over your finances unless you're incapacitated. And then the healthcare power of attorney is also if you're incapacitated, and that allows somebody to make medical decisions for you. And that person, you really have to give some thought to who you're going to appoint for both, because the person that you appoint to act for you to make medical decisions might be somebody completely different than you would appoint to act for you financially. When you're doing a financial power of attorney, you got to think about, is that person a responsible person? Are they going to take out credit and loans and things like that behind my back? Or, even if you're incapacitated, are they going to take out loans and things like that? Are they going to misuse my funds? But then as far as a healthcare power of attorney goes, that's somebody who's gonna make medical decisions for you, so you really need to have a conversation with them and make sure that you're both on the same page as far as what you'd want done for you if you were, in a vegetative state or a car accident or something like that, and you, were on life support. Do you want life support to be continued for a long time, or do you not wanna be on life support? So you have to have those decisions. I have a lot of clients who are Catholic, and a lot of the older Catholic people, they believe in the sanctity of life, and they would not, pull the plug on their kid if they were in a car accident and in a vegetative state. And yet the kids maybe aren't as devout Catholics as their parents are, and they wouldn't want that. So it's really important to have that conversation, so the person you're appointing is on the same page as you as far as what you'd want done, because you don't want to put somebody in the position where you want to be pulled off life support, and it's a moral, it's something morally reprehensible to them, and have them have to make that decision. Do you know what I'm saying?
Oh, yeah, I mean,
Makes sense.
I lived it. I mean, I was my financial power of attorney for my father, but it was my uncle who was the medical power of attorney. Right. Which I was so thankful for, to take that off,
Yeah.
quite honestly, because it'd be emotional for me, and uncle being a doctor, it just made sense, and I just think it just made sense in Iowa.
It's very hard emotionally. I have a client now who, she was the power of attorney for her mom. I mean, she was the healthcare power of attorney for her mom, and she had to make the decision. She had COPD. She was young. She was in her, 50s, 60s, and she had to make the decision when she couldn't really breathe anymore to pull the plug on her mom. And, her brother didn't necessarily 100% agree. And so she's very conflicted about, afterwards you have a lot of, did I do the right thing or not? So it's a really important decision who you pick. And that there brings up one other topic, which is there's something called a living will, which is completely different than a healthcare power of attorney. And the living will is something that, so a healthcare power of attorney is very broad, and it basically lets the person that you appoint do anything that you would do. They could step into your shoes and make any kind of medical decision for you. Whereas the living will, is very specific and it says, if I'm in a vegetative state, this is what I want. Pull the plug, I'm here, don't pull the plug. If I'm in a locked in condition, this is what I want. Do the, pull the plug or don't pull the plug. I want a feeding tube or I don't want a feeding tube. I want hydration or I don't want hydration. I want, you know, uh, drugs to keep me comfortable or not comfortable. I want cremation or not cremation. Very, very specific, very narrow. But the great thing about a living will is it takes all the responsibility off the person who's your medical power of attorney because you're the one telling the doctor, if I'm in this situation, this is what you do. If I'm in this situation, this is what you do. So nobody has to make a decision for you, even if you can't make the decision for yourself. You've already made it, and your medical provider is supposed to abide by your decision. Do you understand the distinction?
Oh yeah, big time. So it sounds like, I mean,
Well, it was kind of leading me to a question. So it's kind of funny. The last time we had this talk about wills and trusts, my aunt reached out to me. Um, she's been going through some medical issues with, it's a benign tumor, but she's been dealing with issues with a tumor in her brain for forever, as long as I've known, probably 20 some years. And she reached out to me with asking me to be the power of attorney for her and my uncle. Once they, I think they're still kind of going through this process. They don't have a will or a trust or anything right now. So they're still kind of going through that process. But that was leading me to a question, what you were saying. So say that she has certain things she wants done. So how is that documented from like my standpoint? Like, is it just, like say something happens to her tomorrow, but she had told me, I don't want you to pull the plug or, whatever it is. So how is that documented? How do you keep that like,
And that's why it's so important that you actually have a conversation with the person that you're, appointing because the document is written very broadly, the healthcare power of attorney. The living will is very specific. If she has a living will, then you don't make a decision at all. The doctor has that living will and knows what to do in those certain circumstances. If one of those circumstances doesn't apply and she's incapacitated and the uncle can't make the decision, you're the one who's been appointed, then nothing is documented. You just make the decision. And so it's important for you to have the conversation with her. What do you want?
yeah, at the mercy of you at that.
yeah, yeah. So it's really, so that's why it goes to your point that you want to trust the person that you're having doing it, because if you tell it, you want this, you want them to do X, Y, and then they do something else. So, okay.
Yeah, because 'cause they're not bound, they're not bound by anything as far because there's nothing in writing except saying that you're the person who's gonna make the decision. But, it's all based on conversation that you had and you knowing the person and understanding what they would or wouldn't want. Um, and a financial power of attorney is kind of the same way, except it's a little my documents are different. I don't know about anybody else's documents. But my financial powers of attorney have probably maybe 30 different powers that you can have, buy businesses, start a new business, open credit cards, pay taxes, just a whole everything that you could possibly think of. And you get to actually sign on the line. You have to initial each line to say what if you give your financial power of attorney that power to make that decision for you. And so you could actually go through that and go, and say, I'm really comfortable with this person making all these decisions for me, but I really don't want them to make X, Y, and Z. I don't want them to be able to take out a credit card, say. So that's, my documents are different in that way, in that you could actually select certain things in the financial power of attorney, but the healthcare power of attorney, wide open. They step into your shoes. They can make any decision that you would be able to make. So that's really important that you communicate with each other about what you'd actually want and make sure that they're willing to take that responsibility on. It's really a great thing that she reached out to you and said, I'm thinking about this because sometimes people just name somebody in a document and they don't even talk to them. And that person doesn't know until they're in a crisis situation that they've been the one appointed to make a decision on their behalf. And some people don't want that responsibility. It's like humongous responsibility.
Boy.
I mean, I was actually a little surprised, but I mean, I think she trusts me and whatever she has to do. But like I said, it was just funny because it came up after we had the initial talk with this and she was going through, she had some stuff. She goes to Mayo. So she lives in Nebraska, goes to Mayo to have the stuff done, and then
Well, she's mortal.
yeah,
It's now they get that's when they realize, right?
and it was funny because it was probably about a week after we had the last podcast about this. She called me up, and I was kind of taken back at first. I'm like, oh, we actually just talked about this. So yeah,
I'm kind of surprised that at the especially being in your position in your line of work, being obviously more dangerous than most professions. I would think that that would be kind of part of the process, is they would have you set some of that stuff up. I think it seems like that. Wouldn't you think, Cindy? I mean, isn't that kind of crazy? It just seems like dangerous jobs that would be proactive with that.
You would think so. When you do go into the hospital, lots of times, if you're going in for elective surgery or maybe not even elective surgery, just surgery that you have to have, they will often ask you, "Do you have a power of attorney?" And if you don't, you can do it in the hospital, and it's a very simple form that they have in the hospital. But if you're in a car accident or you get hurt in the line of duty, you need to have these documents in place so that you have somebody to act on your behalf if you can't. But to your point,
I'm sorry.
what's up?
No, I'm sorry. Go ahead. I mean, I thought
Your point, Mario, you said that for your dad, your uncle was the power of attorney because he's a doctor. And that makes a lot of sense. You choose somebody that it takes the emotional responsibility off of you, and it's also a medical professional, so you think he's probably going to know best what to do.
we had a situation that I would have just been mortified to have to make the decision.
Yeah.
Right. I just would have been, I was the wrong person. I would have consulted him regardless, you know, but, I have it. If I did have to make that call, it just would have been a really bad situation. So, so does it matter? All of these documents that you're referring to, are these just across the board, state to state? It's the same, or is it one of these things again where it's state by state? It's different.
It's all state by state. What is So every state has different laws about what you can put in the documents. They're all going to be pretty similar. Where it seems to vary state to state is what you need to make it valid. Does it need to be witnessed by one or two people? Does it need to be notarized or not notarized? Can it be handwritten or not? Does it need to be, typed out? What's the qualifications to be, validly signed? Some people, this is really back in the old days, they couldn't sign their name, so they'd make an X, so there were requirements for people to be able to attest that it was the person who actually made the mark to sign the document. But a lot of that has carried over, and it's still in the Arizona statutes, but so the documents typically, and I don't practice anywhere but Arizona, but they're similar, and just really the execution of what needs to be done in order to make them valid under state law seems to vary state to state, but they are going to be very similar documents for the most part.
So going back to your situation with Nebraska, yeah. But so if you just have a family member that lives in Nebraska, but they did documents in Arizona, but they live in Nebraska, how does
Because they do documents in Arizona?
no, no, no. She lives in Nebraska.
what if someone did that though?
Oh, she was saying like if it was like flip flop, like maybe she lived here.
Or what if you just signed them here in Arizona, but you moved to Nebraska, right? Now and then you have to
So they're still valid in the state where you did them. So if you did them in Arizona and you moved to Nebraska, they'd still be valid in Nebraska as long as they were valid where you signed them. Under the law where you sign them. And like my documents all say that they are interpreted under Arizona law because I'm an Arizona attorney and I know what Arizona law is. But even if she lives in Nebraska and she does all of her documents in Nebraska, she can appoint you even though you live in Arizona, and it doesn't matter. It just means that whatever actions you take, they're going to be bound by Nebraska law. So if Nebraska law was somehow different and it said you can't pull her off life support, then you'd be bound by that. But it crosses boundaries. You don't have to name somebody in the same state, but you usually do your documents in the state that is your primary residency.
so obviously life circumstances change, right? So it's probably pretty common to kind of start up your initial set of documents and just every so often periodically update the documents.
That's correct. So you should update your documents whenever you have a major life event, a death of a spouse, a divorce, children, grandchildren. And for powers of attorney in particular, financial institutions don't really like them to be more than 5 years old because relationships do change. And somebody that you trusted 20 years ago may not be alive anymore, or you might not trust them. May not be in your life anymore. They may be having drug or alcohol problems. So financial institutions typically like you to redo your documents your powers of attorney every 5 years. And medical professionals also prefer that they are within the last 5 years or so, so that they're sure that you're appointing somebody that you still want to act on your behalf. Even if you're appointing family members, you know, family relationships go up and down. Sometimes you're estranged and sometimes you get back together. So it's really important to keep them up to date. And it's not hard or expensive to redo these documents.
So what do you have to do if you had to redo it? Like, if you didn't wanna change anything, and is it just signing a new thing or
Addendum or something.
So for healthcare powers of attorney, I just print off a new document that would be exactly the same. It wouldn't have changed at all, and you just take it in front of a notary and your witnesses, and you just re-sign it. As far as wills and trusts go, you do a codicil to a will so that you're only changing the one or two little things that you need to change, like who you want to be your personal representative, or if you want to divide your property a little differently. And it basically just says, my last will and testament, I want to keep everything the same, except I want to change paragraph, article B that said this, I want it now to say this. And then the same thing with the trust is you just do an amendment to your trust and you just change the one provision or the two provision that you want to change. And then you just attach those amendments to the rest of your estate planning documents. You put them in the same place so they can just refer to that. And they all refer to each other. Um,
And you always have to record. Is that a separate recording?
You don't typically record your trust or your will. You record your certificate of trust so that there's proof that you actually have a trust. And it has very limited information so that people don't know what your whole trust says and the property that you
Right.
have and who's going to get what you get.
Mhm.
But it's enough to give people the knowledge to know what the name of the trust is, when it was formed, who's authorized to act on your behalf, and what their powers are. And that's all you're supposed to have to turn over to somebody to prove that you have a trust, although sometimes banks require you to give them the whole trust document, and not just a certificate of trust. And then, so that's really the only thing that you record. And it's like 2 pages, it's just a portion of your trust. And then the other thing that you typically record is your warranty deed that transfers your home, your real property into your trust. That needs to be recorded so it's a matter of public record that it's now in the name of your trust. But otherwise, everything else is pretty private.
The living will and all that stuff. Yeah. So with living will, getting back to that, because that's really intriguing to me, right? Especially to avoid. It seems like anytime there's siblings, you should definitely. It's a responsible per parent thing to have that living will there, so that way you don't have bickering amongst I have two girls, and I'd hate to see them get sideways with each other because they felt differently on how to handle a situation with me. Right?
Yeah.
Yeah. I mean, so it sounds like it's really kind of irresponsible of me as a parent to not have that living will in place of, hey, this is what I want. Pull the plug at this stage. Don't pull the plug, whatever that may be. And it sounds like that can easily be avoided. That bickering, internal bickering, even if they disagree, either way, these are dad's wishes, right?
Yeah.
Yep.
By just creating that document. So that's interesting. I've heard of it, but I didn't think about it for myself.
Yeah, that's exactly right. And that, you do have, especially with siblings, especially if I mean, your girls get along great, but a lot of families, they don't get along and the siblings don't get along. And so if you don't have it documented that this person makes the decisions for me, then you really do have a lot of animosity and a lot of hurt feelings and a lot of, you could end up in court, because somebody one of your children wants to do one thing and the other is fighting, not to do that. And you would end up in court. And that's a terrible situation for everybody.
And so avoidable.
Yeah, and that's
So
the thing is I kinda mentioned it in the last one, that kinda happened with my family. They got I don't know how much my grandpa had documented with that kind of stuff, but there was a lot of like bickering about who could make this decision, who can do this, like, and there was they had a lot of tension for a while. I think there's still a little bit of it going on, but yeah, it's definitely up until then didn't exist. And then after, there's been a lot of like animosity and they're not talking to each other and like stuff like that. So it was tough at the time. Yeah.
Sounds terrible.
Lingers, I mean, that could ruin their relationship for the rest of their lives because they disagree with how something was handled, and a lot of it is religious. So if you don't, have the same religious beliefs, or siblings, differ, some leave the church and some, go to a different church. So it's really important that you, especially if you have, you know, m- multiple children, who are not going to agree, it's important to appoint somebody that to make that decision.
Do you ever see people just put that in there? I want, have my wishes are to coincide with how the Catholic philosophy would handle the situation. Do you ever see something like that, or is it more specific?
Yeah, I don't put that in my documents because I counsel my clients to talk to the person that they're appointing. And typically, and I use that example because so many of my clients were Catholic. That you really have to have a conversation with your kids. Are they still, abiding by what your faith goes by, or if they are starting to have a difference of opinion, or they're not attending church as much as you are, just have that conversation. Most kids will do whatever their parents want them to do. I think where you really see the disconnect is not when it's more when somebody wants to be taken off life support, but the person that they've appointed they find that morally reprehensible that they can't, pull the plug. That's where you have the disconnect. Ordinarily, if you're saying you want to be kept on life support, nobody's going to say, my mom wanted to be kept on life support, but I'm not going to, I'm pulling the plug. That typically doesn't happen. It's usually the other direction.
Hmm. And so, but the living will kind of that trumps the power of attorney.
It sure does.
Right.
So the living will is, it's black and white. If it's this situation, this is what I want done. And nobody makes that decision for you. You've made that decision. It's clear, and nobody has to feel bad about it. Nobody has to feel like they had to make a decision because you made it. And the medical providers just, obey your wishes. So yeah, that's a most important one, I would say.
Yeah, happy to stop the inner bickering and fighting. Yeah, and to have your children and loved ones not sit there and second guess their decision,
Yeah.
right? Because that's the hardest thing. Did you do the right thing? Yeah, and you'll never know, right?
That is the hardest thing, especially if you don't really know. It's sometimes it's not 100% clear that the person will never get better, but they might be suffering. So, you know, it, it's a tough position to be in.
It was tough. I mean, with my dad, I mean, it was a bad situation. It was, and we ultimately had to make that decision. It came down to that, and fortunately, everybody was on the same page, and
Yeah.
so my uncle didn't have to um, go over anybody's head,
Mhm.
right? So that was nice, and I think that made him feel a lot better. But heaven forbid he had to go over, but had to make a decision that disagreed with one of his siblings,
Yeah.
right? For his brother, then that would have created a lot of problems. Uh, so it sounds like the living will is super critical
Super important.
to avoid just any kind of inner bickering and fighting. And I never really thought about it.
That's really the whole purpose of estate planning documents. It's really it's the kindest thing you can do for the people that are left behind, to have named the people that you want to act on your behalf so that they don't have to go to court and figure it out, and to tell everybody how you want your property distributed, and how, the decisions that you want to be made if can't make decisions on your own. It's really, anybody who's been an executor to a will, or a personal representative, or an administrator of a trust, it's a thankless job. It's a lot of work. It's not fun. it takes a lot of time, but if you haven't left directions and they have to start from scratch and they don't know what you would have wanted and they if there's disagreement and they have to go to court and you fight about it and there's money spent, it's just really the most responsible thing you could do is to get your documents in place so that everybody knows who's supposed to be acting on your behalf and how you want things done.
Well, this is you've opened my mind a lot. This is something I've got to get done. Not only the trust, but I mean, it sounds like I need to get this living will blotted out.
Yeah, say the first episode put that in my head, like, man, I need to get this done. So
Oh, especially the privacy side, right? I mean, that was really eye opening. Yeah. So it sounds like again, Cindy, thank you so much. I think this was very informative. This was a great, it's obviously not a fun topic, but it's an important topic. So as much as none of us really want to stop and deal with it, it's something we really just as a responsible aging parent, right? I just had a best friend call me today. He lost his sister, 49 years old. You know, you just never know. So kind of it hits home. But until somebody close to you goes through it, you really just kind of that's down the road.
exactly,
That's down the road.
that's how most people view it.
Exactly. And for you, Officer Ty, I mean, it's really important for you in your line of duty because you know, uh, you never really know. You put your life on the line every day that you go to work. And so you need to have your wishes known. It's very important for first responders and officers in law enforcement and military.
I'm really surprised that that's just not part of your process.
Yeah, I mean,
That's really shocking.
that probably should be a conversation that people have, and like it needs to start. There needs to be maybe more of an emphasis on getting getting guys to at least start thinking about it.
Well, I don't even know why they wouldn't even have you do some basic stuff even in the academy.
Well, I think I said in the last episode, like they do it a couple times a year, but they'll do that Wills for Heroes, and it's a free service, and they'll send you stuff out, and like I don't think that many people do it. But surprisingly, I've had multiple times, like even when I was in law school, I didn't, I volunteered and did some of that stuff, and I still didn't get it done. So I don't know if it's one of those things like we talked about last time, where it's just you don't want to feel like it makes things more real. Like it makes you think like shit, like something could happen to me, like and I got to think about this stuff. So
It's almost like you're tempting fate. Like if you do it, then it's like a acknowledgement that okay, now something could happen to me. Put your cheeks in yourself.
Didn't you tell me Cindy, that you created an easy path for people to just online go through and answer a various, some templatized questions to make the process a lot simpler for people? Could you tell me a little
Right. We're in the
bit created?
we're in the process of getting that up and running now. We've coded all the documents. We've got the website done and we're getting ready to plug it all in. And it's really for because we asked me when the age limit of the people that I talk to, my clients. And that's the one thing is if they're younger and they have younger kids and they're going on a vacation, that's when I often get the call from the younger people saying, we just realized my wife and I are going on a plane trip and we're going to be away from our kids for the first time. And if the plane goes down, we need a guardian or conservator appointed for our kids. And that's the only time I get call from younger people usually. But I'm putting these documents online so that if you're thinking about it, you're getting ready to leave town or there's something happening, and you don't want to call an attorney, you don't want to go to the expense and you don't want to talk to somebody, you can fill out a questionnaire, pay, online, and then once you answer the questions, it'll generate the documents and then you just take them in front of a notary and in front of witnesses and you sign and you're done. And it's hopefully going to be a very easy, painless process. So we'll see.
Is that, and you say that's almost up and running or is up?
Yeah, it should be up and running in the next month or 2.
All right. Do you already have a website that people could look for? Could do it.
It's gonna be my Phoenix Legal, let's see, myphoenixlegalteam.com, I think. Not 100% sure.
There. No.
Yeah.
Make sure. All right. Well, either way, we'll make sure we get that correctly across somewhere in the comments. I make sure people can find it. Cindy, thank you very much for coming on board, taking the time to educate us a little bit. I appreciate. Sounds like there's we could really spend some time probably deep diving a little bit on each of these documents. I imagine do's and don'ts and are things to be aware of, right? Maybe not. There probably isn't a good do or don't. It just depends on your situation.
Yeah.
Right.
The ultimate word depends.
It-
It always depends.
Yeah, so it definitely seems like there's more that we can go into with this stuff.
Well, and maybe next one. I think that one thing that'd be very interesting, especially in today's environment, um, is some of the blended family challenges. Right? I think that could be a really big topic. Yep. I mean, right here, we
Two of them right here.
yeah, I mean, it's just very common in today's world. And so it's not really I'd be really curious to have some conversations on
Yeah.
eh, uh some struggles with that. What people are what they're having to kind of address, things to consider,
Yeah.
right? I think that'd be a great topic for the next time if that'd be okay with you.
Absolutely.
Okay. Sure. All right. Well, awesome. Well, I think that's probably a good jump off point.
Yeah, I think so too.
And you have any other questions pertaining? Yes.
No, I don't think so. I think some of the broader topics maybe, but we can get into that another time. But what we talked about today, I don't have any other questions.
Okay, cool. This was great. Time just flies. I don't know how long it was, but I'm sure it was longer than we realized.
Yeah.
Okay, well, cool. Thanks again. High five.